Alright, I guess we can get started. Yes. You all want to make yourself comfortable. I want to, on behalf of the Honorable Barbara Lynn of Court, we want to thank you all for coming and the esteemed panelists today. This is our first event in a series of 3 events we are having at UT Dallas from our of Court. And we are really grateful for Professor Ravi Prakash for facilitating this series of events. So my name is Srini Chakravarti. I'm a partner at Slater Matzel, and along with me is my co-organizer Jordan Strauss. She's a partner at Monk Wilson Mandela. We are both Dallas-based firms. The Inn of Courts was founded by Honorable Barbara Lynn, who's the former chief judge and current senior judge of Northern District of Texas. Judge Lynn made history as being the first woman to serve as chief judge of Northern District of Texas. She's very well known and in the community, very respected. So our Inn focuses on IP or intellectual property, and we have a number of former judges and judges, as you'll see today, and practitioners both in-house as well as in law firms, as well as law professors and students and associates. So it's a very diverse community of people who are part of the Inn. So today we are very fortunate to have a very distinguished panel. You guys are, it's an amazing group of people we have today, which we want to introduce quickly.
Yeah, and I think we can invite the panel to be seated if they'd like to be. But we have Judge Rutherford with us. We're very honored that she's here today to speak with you and share her experiences. She serves as magistrate judge for the Northern District. I believe she is on her 7th year, sworn in 2018 by Honorable Judge Lynn. She also graduated top in her class from SMU Law, I believe number 2. So we're very honored she's with us today. We also have Max Ciccarelli, who is the founder of the Ciccarelli Law Firm. He brings over 30 years of experience in complex intellectual property cases. And prior to founding his own firm, he was a partner at Thompson & Knight. Joined with us is also Miranda Jones, who is a shareholder at Winstead, and she previously clerked for the Federal Circuit for the Honorable Judge Newman. We're also joined by Dalton Eschberger, who is an associate at Baker Hostetler, where he focuses on patent prosecution. And last but not least is Jay Gerstein, who is a law student at SMU. So we want to thank all of the panelists for their time, and we're excited that you're going to learn from their experiences today.
So we want to kick off with a quick presentation that'll help you understand IP in general, like a general introduction to carriers and IP. I guess we probably got seated, so you guys want to kind of come in and do the presentation?
Or I can run the slide.
Oh, we can run the slide,
yeah.
Sure. Oh. It's on the back, that's the problem. Oh, right, so then you want to rotate.
You can rotate
over to the side.
Oh, shoot.
Yeah, just let us know when to flip the slide.
Yeah, who wants to start?
Okay, I'll start. All right, so we're here today to talk about intellectual property. I'm sure you all know what property is, right? It's your house, cars, whatever it is that you own. So intellectual property is the ideas, creations that the government has created rights that you that own. And almost every company that you'll see today has some form of IP. And so we're going to talk about some of the different forms next.
Can I ask a question? How many of y'all had heard of the term intellectual property before today? Awesome. All right. It's a good start. I guess, why protect intellectual property? Does anybody have any idea why you might want to do that?
It could encourage innovation if people know their ideas are protected.
Exactly. And like copyrights and patents are actually called out in the Constitution for exactly that, to promote innovation, right? If you can protect an idea and get some value out of it, it entices others to do that and to put money into research and development. And that promotes the economy, and that's one of the reasons, I think, why the US is such a great economy, is because it's put a lot of money into research and development. So, copyrights. Who wants to do copyrights?
Sure. So copyright is a form of intellectual property that focuses on creative works and works of authorship. And basically the two kind of big ticket items for copyright is that it's some form of expression that you've fixed. This is often a book, it's articles, paintings, drawings, but often now we see a lot in terms of code and many companies use it whenever they talk about like technology transactions and very, very heavily used across the spectrum.
Including their notes from class, copyright.
Very true.
Right?
Very
As
true.
soon as they become fixed on paper on your computer, you now have a copyright in your notes in case somebody tries to copy it.
I actually had a case involving a social media influencer who had a copyright on some of the photos that someone else had then posted on Instagram. So there's interesting ways that copyright can work.
I mean, I assume most of y'all have heard about copyrights. How many? Yeah, from probably social media.
Go ahead with this one. So there are different types of patents. Everyone understands that, patents would probably protect your inventions, the things that you create. There's different types. There's utility patents. Think of it basically as like protecting, the newest engine in a car, or a new method of making something. There's also patents for, let's say, a drug or a composition. And then you have design patents generally, so you have a patent on, say, the latest Tesla model, just the way it looks, the way it's designed, the way it's presented. Nothing to do with functionality, which is the realm of utility patents. And design patents is just more of what does it look like, what can we protect. And there's some significant differences between the two. And for the most part, we focus on utility patents, but design patents are pretty essential. A lot of us probably are aware of, the Samsung, Apple lawsuits. I think everyone's ever at least heard of it. So some of that was focused on design patents, just the way, for example, the apps looked on a home screen between Samsung and Apple. Samsung copied the little square block look. And, design patents and software are becoming a bigger thing because of that particular lawsuit. And it's always something to keep in mind when you're looking at patents. You have the functional aspect, the utility of it, and then you also have the design aspect, depending on what it is, of course.
Yeah, it's funny. My practice actually sparked pretty heavily from the Apple v. Samsung case. We do a lot of user interface work, which is, as stuff moves more and more to being developed by AI or have some kind of AI backing, it kind of gives companies a way to protect the way that they look, even if the background software is not as novel. Maybe it's just based on ChatGPT or some other AI.
Can I ask a question? Meaning, as a computer scientist, from the moment visual interfaces came over, a rectangular thing structure to represent anything is kind of obvious. So is it possible that these protections sometimes get in the way of innovation? Because if that's the natural way to show anything, aren't you forcing somebody to take a different approach?
I think that's an interesting, and it's true. I think there's a lot of people that give kind of a cynical view of the patent system broadly, right? And it's inherent. You're providing a monopoly on some kind of idea or some kind of way of doing something. And to your point, a lot of UI work is less of how these baseline elements should look together, but more like how using some form of user interface we guide a user through some functionality in a piece of software. And so I don't think it's as inhibitive in terms of like people being able to progress through how they want to, but it does keep certain companies to have like their look and their feel, and I think that could be important.
But to your point, right? If one way of doing it is protectable, then other people have to come up with different ways.
Right.
Maybe they find better ways. And by the mere fact that you can get protection, it gets you to think ahead and say, okay, let me create something that is better to then get a patent on and keep others from doing it for a certain amount. Patents are only good for utilities for 20 years. So after that period expires, then it's open, right? So I think in either case, it helps motivate more development.
And there are also safeguards, right? There's all the concepts of prior art and obviousness, which prevents you from taking whatever you want.
And I guess with patents, the idea has to be new and not obvious. Those are two key sort of tests, right? So even if somebody has done it sort of in a similar way and you're doing it a little bit differently, are you changing it enough to where it just wasn't obvious to make that change? And that's what you ask yourself every time. Is this patentable? Those are the two questions that you generally ask.
Well, that leads us into the next slide, which are the requirements.
Oh, sorry.
So there are certain requirements that you have to meet in order to get a patent, and it has to be useful. You have to describe it. That's the whole point of getting or having the patent system, is that you're disclosing what the invention is, so that after the patent expires, someone else can use it. It has to be new or novel, not obvious. So new or novel means like exact, essentially. If there's something that's exactly the same, everything that you're claiming is in the prior art, then you're not going to get your patent. Obvious means like combination. So let's say taking this element from here and another element from somewhere else. And if what you're doing and putting together would be obvious, then you can't get a patent on it as well. And we all know different examples of patented inventions: telephone, light bulb, iPhone. There are so many different aspects of every device that are patented these days. So if you talk about an iPhone, it's just so much technology is inside the phone. There are probably hundreds, thousands of patents that may cover one device.
And it covers things that these patents cover things from complicated technology or computer devices to very mundane instruments. I had a patent case where the invention in dispute was the styrofoam plug that you put in the base path when you pull the base up so that dirt doesn't fill in the hole. It was basically a round hole and a round peg, and it had like a little flag on top of it. And a bunch of people make these plugs for base paths and sell them at Dick's Sporting Goods and Walmart. And so that was what was being that was the patent case. I had another case where the patented invention was hair extensions, and whether the patent, which called for a combination of real hair and synthetic hair, could be infringed by a product that was 0% real hair. So some of these patent careers or IP careers require a lot of hard science, but then fortunately there's plenty of cases where people like me who took math for liberal arts majors, I can understand hair extensions. And I can understand a combination of real hair and synthetic hair.
I think there's a question.
Yeah. So are there any ethical regulations on patents? For example, I see insulins up there. The Salk vaccine, I believe, for polio is famously not patented. So can the government, for example, do anything someone wants to patent, like an orphan drug, and like charge whatever they want for it?
I think that's a complicated question. I know that there were some issues around that with the COVID vaccine and about perhaps the government stepping in to prevent certain patents from being enforced, at least. But generally, no. So if a person wants to, I will say this though, the pharma industry has a lot of other patent regulations and statutes that come into play because there's a whole generic manufacturing industry, and so that's a whole nother presentation in of itself. But there are there's a careful bargain that was crafted around that, around what can be patented, when are we going to allow generics to try to challenge those patents, and how that process is going to go. Because I do think there is concern that we want drugs to be affordable for people, and of course the pharmaceutical industry says, well, we have to recoup our amount that we've paid for R&D, and we have to pay for all the drugs that didn't make it. And so it's a complicated question for sure.
There was a situation, I think, where somebody had cranked up the price of some drug,
Yeah.
like 700-fold.
Was it? Someone know about this? It was something everyone used.
Yeah.
It was everything.
Yes, that's right. That's right.
But bottom,
I needed them. they went from like $50 to $700.
from a patent standpoint, you can still get the patent on the COVID vaccine, et cetera, right? You have a property right. Then the question becomes, what does the government do to divest you of that? And then do you have a remedy to get paid by the government because now they're taking away a right that you had? And I don't know the exact answer to your question, but it gets pretty complicated.
But I mean, as a policy question, right? You're as she said, you are incentivizing people to put money into expensive R&D, and in return, you're getting some limited rights on the patents for a limited time, right? If you don't have any incentive, who is going to invest in the R&D for the next drug, right? So that it's a balance between those two. And whether we are at the right balance or not, we can argue, but that's the balance.
I was going to say, the pharmaceutical industry has been criticized some for evergreening their patents, which means you start claiming all of these different aspects of a drug, like dosage form and how methods of use and things like that. And so there are some ethical limitations. You can't commit fraud on the patent office. You can't say something's new when it actually wasn't, and there's evidence that supports it. So there are ethical, limitations from that aspect, but there's certainly a number of different ways you can protect the same drug for a very long time.
I was going to bring up her last point there is patent prosecutors, or the attorneys, the people that help inventors and companies get their patent, have a ethical obligation and a legal obligation to report prior art that they know of. So, just to backtrack, what prior art is, like something that's already occurred. And so it's very difficult to, go out there and try to get a patent on insulin a second time. And so there is somewhat of a restraint on patents. You can't get something forever. There's going to be a systematic ethical obligation rather than just a broader picture like, oh, we don't think it should be ethical to, patent drugs, because like Srini said, you need some incentive to create those drugs.
Right. I mean, just to clarify, I think we use the word prior art all the time, without even thinking. So it has a legal meaning, but at the basic level, it's everything that's known in the art, everything that people know. Your journal articles, your patents, your newspaper articles, everything that's known related to that, invention. And as Jay said, we as a prosecutor, I'm a prosecutor, have an obligation. When I work on a patent application, I have an obligation to disclose everything I'm aware of that's related to the invention to the patent office. So we are not supposed to hide things that'll get us into trouble. It's not worth risking.
And there's nothing that says an inventor must seek a patent. I think famously, we're talking about the Constitution has recognized the right to patent inventions since it was enacted. But George Washington had a invention for a threshing floor, and he famously did not seek a patent, even though that protection was afforded by the brand new Constitution, because he wanted it was such a great invention. He wanted everybody in the new country to have a more effective way to thresh their wheat. So he didn't seek a patent. So the right exists whether the inventor avails themselves of protecting that right. And then once you have it protected, whether it is worth it to you economically to enforce that right through the system that we have, these are additional questions. So perhaps that has sort of layers on those ethical considerations.
I didn't know about Washington, but more recently, Elon Musk at Tesla, some years ago, dedicated all of Tesla's patents to the public, so that now anybody can use those patents.
Another very classic example is Bell Labs. You know, we all know transistor was invented in Bell Labs, and they had all the seminal patents on transistors from 1947 onwards for the next 10 years. And they had this seminar where they called all the companies who were interested in learning semiconductor physics and technology to come in, and they could just pay like a very nominal $5,000, $10,000 fee and attend the seminar, and they taught them everything. That's how all companies like TI and a whole bunch of companies spanned from that, and they just gave away. I mean, that was very, very valuable, but they made a decision to give away their patent portfolio and teach how it's done.
So this is all sort of from, the public sector, or the private sector, I should say, but there is some from the public sector, from the government coming in and saying, okay, previously discussed, maybe we do want some of these to be open to the public without having a patent in the way. And one example that I can think of is, how many of you have used like a table saw before? Has anyone used a table saw? Seen one? One? Two? If you've ever heard of SawStop, it's basically technology that if your finger gets too close to the blade of a table saw, which will very easily rip off your finger, and it's an extremely common injury for anyone who uses saws, the patent protects, or the patented invention protects your finger by immediately stopping and getting the blade away from your finger before it can even cut your finger. Like, it senses the proximity of your finger. It's basically based off of an electrical circuit that can sense a change in the circuit because your finger touched the blade, and the blade immediately goes away. And that's been protected for nearly 18, 19 years. I think the patent expires this year. But OSHA actually put out a regulation proposal saying, hey, we actually think that we can really help people by requiring this technology. And they went to SawStop and said, we want you to give this out to the public because we can really help people here. We want you to give this up. And the company actually agreed to release the patent early, and we're like, okay, we'll let you have it early. And they had a grip on the market forever, and that's got to change because the government was like, we want you to release all your patents.
I have a quick follow-up based off of that. Can, for example, in a time of emergency like the pandemic, if you develop a vaccine and you don't apply for a patent, can you apply for one like a year or two later, or is there time limitations?
So there are time limitations. The basic rule is you get up to a year to file. Patent practitioners would hate if you did that. Please talk to one first. But technically you do have a grace period to obtain a patent. But if you go over, then you've lost your right to a patent.
Right. Something that was in public use more than a year before filing is prior art, essentially.
Awesome. So another way that companies protect innovation or their R&D, or what makes their product kind of the secret sauce and beat other people in the marketplace, is trade secrets. And so these are generally anything that you keep a secret that has some kind of industrial value or value to an economy. Probably the most well-known is the Coca-Cola secret formula. I think one of the interesting things when you see trade secret cases is, did the company do enough to keep it a secret? And Coca-Cola, if you read about how they keep their stuff a secret, it's like every person along the line knows like one part of 50 steps and doesn't know anything else. And so if that person leaves or quits or whatever, the company, of course, makes them sign NDAs. But even if the person did decide to leak everything, like, the company would still be successful in keeping their product their own. So usually a little more economic solution. It's also something you'll see a lot whenever people put a product to the market and potentially lose out on patent rights. They don't pursue them in time. You'll pursue trade secret rights.
Trade secrets also applies. Most companies have trade secrets. Applies to things like your customer list if you keep it secret. right? Your revenue numbers if you don't publish them, right? Things like that that are pretty mundane that most companies have. If they're keeping them secret, they can qualify as trade secrets. So if an employee walks out and takes them to another company, you have a cause of action to go try to stop them from doing that or stop the new company from using it, et cetera.
The advantage of a trade secret over a patent is the length of time. If you can keep it secret, it will just continue in perpetuity to be your secret, and you don't have to disclose it like a patent does and then just have those rights end after 20 years. But the trade-off is you actually have to be able to keep it secret, which it's really hard to do, it turns out.
So is source code trade secret? Source code of, say, Microsoft Office?
Yeah.
Oftentimes.
If it's kept secret, not the object code, obviously, because that's publicly
That is
available, but the source code.
Is a trade secret?
Trademarks, anyone? I'll do it. So trademarks is basically a way for somebody to recognize the source of your product. The example I give is when I had my little boys in the car when they were little and they would drive down the street, they'd point, there's, coffee, Starbucks. They couldn't read at that time, but they saw the Starbucks logo, right? And they recognized that as the coffee that their mother drinks or whatever. And so you also have the name, Starbucks is also a trademark. So that's a way to really make sure that when a customer sees a name or a logo, they associate it with your product. And if they do that, then that's something that you can protect so that somebody can't come along and start using something that's really similar. And there's cases about various coffee shops making different versions of the Starbucks logo, for example, right? And so that's another way that you protect sort of your image. And there's parts of trademarks that are also trade dress, like the shape of an object may be qualify as trade dress. And the good example there is the classic Coca-Cola bottle. Don't see as many of those around nowadays, but that was a unique shape. There's no reason to have those little swirls on the outside other than it looks like our bottle, right? So things like that can qualify for trademark, trade dress protection.
Yeah, the red bottoms of the Louis Vuitton shoes, that's trade dress.
Tiffany blue,
Yeah.
the Harley Rumble as well. On this one.
That is not protectable.
I thought there was one.
I fought over that.
All right,
So we're going to talk about careers. Well, I just finished, but I guess by way of introduction, there's a lot of different ways that you can deal or work in the intellectual property field, right? And we're going to go through and try to describe some of those just to give you some ideas. We probably won't cover them all. And within each one of these, there's different subclasses, but hopefully this gives you an idea of if you're interested in that kind of stuff, what careers can you pursue that might get you more involved with it? Who
Well,
wants to take?
I'll do this one. So anyone who has an idea that has been reduced to practice can file for a patent. You don't have to have a special qualification or expertise or anything like that. We have a lot of armchair inventors who just come up with things just based on their experience in life. And a lot of entrepreneurs start out as inventors and build their companies around their inventions.
Another one, patent agent. So this is, a lot of people do this as a kind of a stepping stone. Potentially, if you aren't sure whether you want to go to law school, I was an agent, and you can do it as long as you have a technical background, some kind of STEM degree or hard science. I think they've opened it up a little bit. It's now, I think, based on like a certain number of sciences. And it's a great way is if you want to know if you want to do patent work, but you don't want to commit to 3 years of law school. And a lot of firms will recruit you kind of heavily if you do go this route, because it gets you kind of base knowledge without going to law school. And by the time you finish, some of your peers will not have that same kind of knowledge. And another one is, you often hear it as like tech advisors, scientific advisors, tech specialists. This is usually somebody who does the role of a patent agent, but just hasn't passed the patent bar yet, which is the test that gives you the patent agent kind of title. Some firms also have them as end up being like a drafting aid, where they do a lot of the technical part. Maybe they have a specific science background that really works well, and the attorneys don't. And so, we have one that does strictly AI, has no intent to being an attorney, just loves AI, and is incredibly knowledgeable on it, and they just work as a technical specialist.
So to clarify, I think a patent agent is practicing only with the United States Patent and Trademark Office, or Patent Office pretty much, right? You're not practicing in a court of law that's different.
So what does a day in the life of a patent agent look like?
Yeah, so it depends a lot on the firm, of course, and what kind of responsibilities, but a lot of practice groups, you will either be drafting new patent applications, and those will be potentially filed at the USPTO, the United States Patent and Trademark Office. And then once it's filed, that application rolls into what's called prosecution. And that's where it's picked up by a patent examiner, which I think we have potentially on the next slide, who is at the patent office, and they tell you, hey, what you filed is not new, right? It's not novel. Maybe this is obvious, like somebody else has been doing this for a decade, and you'll get an office action. And oftentimes a patent agent will handle the office actions for a particular case. Usually you'll have some kind of supervising attorney on the docket as well. But it's a great way to get into patent, because a lot of firms, you will do almost the exact same role as an attorney, just you'll have some kind of supervising attorney. And so it's a great way to kind of lead into being an attorney if you want to pursue that.
And there are a lot of technical people who just are content in a way. It's satisfying to them because it's very technical. If you're especially working with a lot of R&D companies, it's you feel like you're using your engineering STEM skills, and so they don't necessarily go to law school.
It's certainly a good route if you don't know if you want to be in IP at all, but you want to dip your toes in. That was me. Wasn't sure I wanted to go to law school. I actually find the rest of the law not particularly interesting. I'm only in law school so I can do work in patents. So then I went and I worked as a patent agent for 2.5 years, and like you said, it's very dependent on the firm. So I started at a small boutique firm, and they kind of just were like, okay, we're going to treat you like you're an attorney, even though you're not. And you learn a lot, and it's very interesting. You get to talk to the inventors. A lot of firms will just bring you in with that meeting with the partner or whichever attorney is taking lead, and you'll really kind of act as maybe a first-year associate or a second-year associate. But those also aren't the only avenues you can go. Like you said, you could be a patent examiner, which is on the opposite side. So if we haven't mentioned it yet, I don't think we've particularly mentioned it. You don't just get a patent, you have to file an application. And so the patent agent or an attorney will write the application, they'll create it, they'll send it to the Patent and Trademark Office. And then over there you have an examiner. They review it, they say, okay, we think it's patentable, we think it's not patentable. They usually tell you no the first time around, and then you have to argue. It's usually all on paper, it's not like in court. And so that's a lot of what a patent agent will end up doing, is a little bit of writing the application, a little bit of arguing with the patent office, all on paper. And then a new thing that's kind of evolving here is if you're not technical, if you don't have that engineering degree, maybe you only have comp science degree, but you don't meet all the requirements of the patent office, there's this new design patent agent person. I'm not sure if we call them a patent agent as much as this is only within the last 1.5 years. If you're artistic and you want to just work on design patents, you can actually help people who are filing design patents get design patents only. It's relatively new. So it's like working with CAD, getting the drawings up to standard for patent, which are very different from your regular CAD drawings.
So those are the beauties of actually getting the patents, right? But then once you have the patent, what do you do with it? And if somebody's infringing your patent, you have to go to court. And Judge Rutherford knows all about that since she's the judge. you want to handle this one, or do you want me
Sure.
to?
So if you need to enforce your patent, one way to do it is to file a lawsuit, and that sort of kicks off a cascade of litigation practice that may or may not culminate in trial. But in order to appear in court, to represent someone else in court, an inventor, sometimes we have inventors represent themselves. We call that pro se. You don't have to hire an attorney, but federal court is pretty complicated, and there are a lot of pitfalls and traps for the unwary and the unschooled. So a lawyer is going to save a lot of time. Lawyers are expensive, but otherwise it's hard to know how to navigate your case through the litigation system. Motion practice. What is motion practice? I mean, if you haven't been to law school, this concept of motion practice might be completely foreign to you. Which motion comes first? There are a lot of rules of procedure for the cases, and judges are really particular. The case will stall and fail if the rules aren't followed. So these are the things that you learn in law school, the reasons you go to law school, to learn this art of how to try your case, litigate your case. There'll be discovery where you get evidence from the other side about whether there's been infringement. You'll make presentations to the court. With patent litigation, there are additional levels that you wouldn't have in a civil case like a copyright case or a trademark case, because the court has to construe the patent. You've spent a lot of time and energy and money to get your patent, and then you have to take it to a court where there's a judge who likely does not have a technical background, and maybe even someday a jury that probably may not even have a high level of educational background. But the court will construe the patent, that is, tell you what the patent means in the context of this litigation, and there will be a fight over what the words mean, what the claims mean. There'll be negotiations. Sometimes the parties will agree, and then once you have your claims construed, then you have to determine if there's been infringement. So if you think about a complicated case, some piece of complicated technology, engine, something that requires electrical engineers to understand, how are you going to simplify that so that whatever invention, creation, device that you have that's similar to another device, is there patent infringement on what level? Patent cases can take a very long time, years to resolve. Litigation does not move quickly. This picture illustration might be a little bit deceiving because most of the litigation practice looks like paper, looks like lawyers sitting in front of a computer screen, doing research, looking at documents, and writing briefs. It's a lot. It's like the research paper for your English class your senior year in high school. It's research. You're sitting at a computer, you're doing research, you're putting a paper together and turning that paper in, and then waiting and waiting and waiting for the judge to give you some answer on your motion, some grade on your paper.
But in terms of careers, right, there's room for everybody. There's room for the people that really, really like to write and don't really like to get up in the courtroom. And then there's the people that actually enjoy like their debate class or whatever and like to get up there and talk to the jury. So there's really a little bit for everybody, right? And there's places for like patent prosecutors, right? The patent agents that like to get in there and write up these technical patents. I did that a long time ago, don't want to do it anymore. And then there's people that like to be in the courtroom. So there's a little bit of something for everybody. And what I personally find really interesting in this patent stuff is every day, right, every case has different technology. And so you're always dealing with the cutting edge of whatever it is, you're dealing with that. When you have experts that help you in the case, you're dealing with like the nation's top experts in whatever this little piece of technology is, you're dealing with the top experts in the world. And that to me is what makes it exciting. Every day I go to work, there's something different.
All right, so next we have lawyers who do IP transactions. So these are attorneys that really never go to court. They will work in a law firm, help with different kinds of transactions. So sometimes when you have companies being purchased or mergers and things like that, you have to look at the IP. And so you do due diligence, you vet all of the IP that's being purchased, look at the clauses and agreements, and make sure you're protecting everyone's rights. Sometimes the IP comes up when you have startup companies who need to enter into agreements with contract manufacturers and whoever their suppliers are going to be and things like that. So it'd be a transactional attorney that would work on all of that stuff. This is going to be someone who passed the bar exam in the state and has a law degree. So this is more writing and negotiation, not so much oral argument, not so much persuasive writing, more like a prosecutor, it's more of a technical writing.
In-house, I'll address it if nobody else wants to.
Sure.
Every company, not every big company has lawyers that work at the company, right? And they get inundated with questions from all the different business people, right? If their business people have to have contracts with their suppliers, right, or with their customers, whenever they have a new customer, they need a contract. And so there's a lawyer that they call with questions about those contracts. The lawyer may help them draft those contracts. Those in-house lawyers then end up using outside lawyers as well for the more complex or more time-consuming tasks. But that's generally just a different approach, right? You don't have the firm type of environment. You're more inside the business, helping the business run itself. And you may be doing contract work. You may be doing some intellectual property vetting at the front end. You may be helping inventors make sure that they disclose their inventions so they can get protected. That's the kind of work that an in-house lawyer would do.
And depending on the company, like you think about a company, a local one like Toyota, they have a significant in-house legal department, and they have people who help with their litigation matters, people who help with their prosecution matters, people who help with their transactional matters, and they only deal with that one company and with the technologies that company has. So your range of matters that you work on might be different if you're outside counsel, because outside counsel probably has several different clients who are bringing different patented inventions to that outside counsel. The in-house counsel is dealing with just that portfolio of patented inventions that the company has. And so if you have a particular affinity for a specialization, sometimes in-house work can be very satisfying because you don't have to worry about all the other stuff. You've got a client that does what you have proficiency in, and so it's kind of a good marriage. And I think we touched on the types of government jobs that are available with the Patent and Trademark Office. We talked about patent examiners, and they also have trademark examiners, folks that work for the government as opposed to a private firm.
Can I mention something on this? The USPTO, were you going to?
No, go ahead.
So the USPTO was always up in Alexandria, Virginia forever. There's always one. You had to go there you had to mail things there back in the mailing days to file something. Some years ago, the Patent Office decided to open several regional centers. I think there's 4 now. One of those centers is in Dallas. So if anybody's interested in a career with the USPTO, I would encourage you to reach out, call them up, say, look, I'm a student. I want to learn about what career opportunities are there. They will help you. They have a whole outreach program where they want to recruit people. You may have heard recently, I think President Trump just announced he's trying to end the work from home policies for government employees. The U.S. Patent Office was probably the first to start the work from home, and they started before the pandemic. And their whole reason was you need technically smart people. And it's hard to get them to go up to D.C. when they may be in California, they may be somewhere else. And so they realized that in order to acquire that talent, they had to provide the opportunity for people to work from home. So that was that, and the that and the local offices was their way of recruiting talent. And so it's a unique opportunity that we have here. And if you're interested, I would definitely go spend an afternoon visiting.
And it's worth, I also think they have internship possibilities. So it's worth finding out about because it's a whole window to potential career opportunities and certainly opportunities that people who work for the USPTO are very well connected and can kind of spark your or help guide your path if you make a connection with those people and just ask them questions. How did they get in this field? Is there anyone else they would recommend you talk to? Sometimes that can turn into a really solid lead for actual gainful employment.
Well, within universities, there are also IP professionals. So you have IP attorneys who may be in the technology transfer office. This is when the university has departments that have come up with inventions, have patents, and they license them out. And there's usually some attorneys that will help facilitate those licensing deals. Also, law professors, obviously. It kind of speaks for itself. You write a lot and teach classes, as far as I understand.
There's one university that sued on its patents and got a judgment of over $1 billion from a company. So they're realizing that there's a lot of value in their patents and they're starting to assert those. And so there's some big judgments out there.
So does every research institution, like a higher ed institution, likely have patent lawyers because they're doing research ongoing?
I think oftentimes, I used to work for CSIRO, which is the Commonwealth Scientific and Industrial Research Organization in Australia. They certainly have an enormous patenting program, and they have a lot of research. That's all they do. And I think that if it's an advanced and large enough organization, it will.
Today it's very unusual not to have patent people in any advanced R&D. They may not have lawyers, but they will definitely have patent agents because you want to file patent applications.
Do we know if there's UTD?
We do have.
Okay.
We did file a patent for one of the algorithms we developed. But university research gets interesting because the president doesn't know the kind of research that individual faculty members are doing. So unless a faculty member discloses that they have something that could be patented, university is blissfully unaware of it.
And that's where the in-house lawyer at a company, but also the in-house IP people at a university, their job is to educate the inventors that, hey, as soon as you come up with an invention, they usually give them a form. Here's a form, fill it out, send it up, and then they oftentimes have a committee that gets together once a quarter or once a year, and they evaluate all these disclosures and decide where to spend their money, right? Because you have a limited budget, so you can't get a patent on everything. Getting patents is expensive. And so they make decisions as to what technologies to pursue.
And there's a tension in academia in the sense that there are a number of people who believe that our salaries are paid by the public. So if we invent something, we should just give it away for free to the public by publishing it in a journal and not even go for a patent, stays 1 year and becomes prior art. But it's available for free. An example of that is the whole Internet Protocol suite developed by folks at Berkeley and UCLA and other places because it's free to the whole world.
Another aspect of it is that most people don't think of. I don't know. Is anyone here a PhD student? I have no idea. No. You actually may not even have individual rights to stuff that you create in school if it's for school. Like if you're a PhD student, you do research and you come up with an invention, you actually may not have ownership of that. Might actually belong to the university.
Because it was created in a classroom, which is governed by a university.
Yeah, basically. I mean, you can think of it that way. It's
In the corporate
part of-
world, you have an employment agreement,
Yeah.
and 99.9% of the times it says anything you invent at work or using our resources is ours.
And this is an interesting difference, I guess, between academia and the corporate world, because faculty have always stressed that our work is not work for hire. It is our intellectual creation. But in corporate world, you invent something, you have to transfer ownership to the company that you work for, right? So, for example, during COVID, people's lectures were recorded. But university does not have ownership over it and thus cannot deliver that same course without the consent of that faculty member using that recording.
There are also sometimes restrictions if the research is funded by grants. Some of
Yes.
the grants will have, clauses about who owns the intellectual property that stems from that research.
Yeah, like
So-
government contracts, work resulting from government contracts
quick-
too, they have certain rights.
Bookkeeping question. Are we expected to close at 1?
Hmm.
We still have Q&A. so
Yes,
we
I'm
wanna
seeing a
ask-
nod, yes.
Yeah, we have time for a couple of questions, but yeah,
Okay.
we need to wrap up at 1.
Okay, so I think it'll be good for everyone to have an idea of the panel. We gave a very short introduction, but I wanted to kind of at least ask them their individual opinions. So maybe if I can start with Judge Rutherford, can you discuss your educational background and how that sort of relates to your current career?
Sure. So I have an undergraduate degree in history. I taught 7th grade language arts and history after I graduated, and kind of went to law school because I didn't want to be a teacher forever, and I really liked the TV shows like Law and Order and LA Law. So it looked good on TV. I thought I was a little tired of teaching, so I did that instead. After law school, my first job was I worked for a judge who is still one of our senior judges here in the Northern District of Texas. And so it was all litigation, all trial court, but in federal court, we do civil and criminal. On the civil side, we do employment cases, we do contract cases, we have securities cases, and we have intellectual property cases. And so after sort of really getting my feet wet, seeing a little bit of everything, I went to a law firm and I did real estate law because it was late 90s and you did real estate if you were in private practice. And so I negotiated leases. I helped clients get easements for their parking. Stonebriar Mall was just going up and we worked on a lot of construction projects around that. After about 6 or 7 years, I didn't want to be a real estate lawyer anymore. There's only so many apartment buildings and shopping center leases you can negotiate. So I went back to the federal court where I could do a little bit of everything. I worked for a couple different judges again, including Judge Lynn, who the inn is named after. And with her, I worked on a lot of patent cases. At the time, the court had a patent pilot project. We were trying to attract more patent litigation to the Northern District of Texas because of some interesting venue provisions, which is one of these legal rules that you learn about if you go to law school. There is a lot of choice about where cases can be filed. And so there are a couple of courts in the nation that have almost all of the patent litigation, in part because they're efficient and their judges are seen as very knowledgeable. So Dallas was trying to attract more of those cases. So several of the judges got really up to speed on patent litigation. They took extra courses and they were working to attract patent litigation to Dallas, the Dallas courts. So I worked for one of those judges and that's how I kind of got into this sort of patent interest. Most of what I do on a daily basis is not intellectual property work. I would say on the civil side of my docket, the civil cases, maybe 15% of my cases are intellectual property, and that includes the copyright and trademark. Really, the variety is incredible. In addition to all of the different things we do on the civil side, I also have criminal cases. Criminal cases rarely touch on IP, although interestingly, as technology becomes more and more prevalent in our lives, some of the criminal process that the agencies use, like where is there going to be evidence of a crime? On your device, because it's going to have your location, it's going to have your admissions that you've made in text messages. We have, so the more prevalent technology is in our life, the more it's going to create evidence that the law enforcement agency and the prosecutors will need. And so, interestingly, over the course of my now 30-year career in law, that is where I'm starting to see a lot of this. That we're not enforcing IP rights, but there are a lot of technical questions that come up in that criminal arena. So it's kind of interesting.
Thank you, Judge. So on the other side, I think I want to ask Max because he's been a litigator and a prosecutor and immersed in IP, if I'm not wrong. all his career.
I went to engineering school, got a mechanical engineering degree. I thought I was going to go get an MBA and go that route and be in a company. Then I met my wife in college, and she came from a family of lawyers, and she was going to go to law school. I also had a couple of professors that had gone to law school to learn about IP, et cetera, and now we're back teaching engineering. And so between all that, I was like, this could be an interesting route. I get to deal with technology, so I started doing prosecution initially, my first year, and then quickly transitioned over to the litigation side. And I've been doing litigation pretty much exclusively ever since for the last 30 years. And so I litigate, but with a technical degree. There's also folks that don't have a technical degree. One of the partners I worked with for many, many years, which Judge knows, he didn't have a technical degree, but he was outstanding, right? Because when you are doing those kind of presentations, when you're trying to simplify these really technical things for a jury that has maybe a high school education, it's not easy. And you'd be shocked how many times we talk to folks in other countries that are like, wait, who decides your patent case? We're like, a jury. Who's on the jury? We're like, regular folks off the street. They're like, how can they understand, rocket science, literally, right? And somehow we need to find the skill to communicate that to the jury. And so technical degree helps in some ways and non-technical degree helps in others, and all are welcome. And that's how I got into IP.
Thank you, Max. So finally, before we open up the question, I want to ask Miranda the same question.
Okay, quickly, I got a degree in chemistry and studied chemical engineering as well. I kind of fell into the law because I didn't want to work in a lab anymore. And so I went to law school. I worked at a small firm. Well, I worked at a big firm first. I clerked for a judge in DC. And then I came back to Texas, worked at a litigation boutique where I was able to use my chemistry background because we did pharmaceutical antitrust cases where, touching on the question earlier, we helped generic manufacturers get to market. And so I'd work alongside sometimes the FTC, generic manufacturers, and various class plaintiffs, wholesale drug companies who wanted to be able to sell the generic drugs. And so it was a really interesting practice because I would handle only the patent part. There were other counsel who would handle more of the antitrust and damages pieces of the cases, but I would, evaluate the patents that the branded companies were using and figure out whether or not they were valid and enforceable and good patents.
Right. Thank you, Miranda. We have a couple of minutes. Anybody has questions?
Maybe I can ask a question on their behalf.
Yes.
As litigators, you, I presume, have interns who are law school students. But what about undergraduate students who have yet to go to law school? And if they want to understand what the career would be like, what are the opportunities available to undergraduate students?
So you're right. It's more common to have law students come in and intern, especially at the larger firms. But if you have a technical background and you're interested in that, I think contacting some of the smaller law firms, and if you reach out to us, we can give you tools to find them or point you in some directions. But like these guys here, I don't know, do your firms hire?
Yeah, we had 2 people who came in as interns who were going to be, the goal was for them to be patent agents. And they came on. One was a junior in undergrad, and one was finished up in undergrad. And you'll find that probably shops that do patent prosecution will be probably more open to that sort of trajectory. Is that something you can?
If you want to sort of get experience, let's say, on the courtroom type stuff, the best thing I think is go to the courthouse and watch cases. Go find out when the next patent case is being tried. Go watch opening arguments, go watch a few witnesses.
And that's available?
It's open to the public. There's portions of each trial that may be closed because of confidential information, but like opening arguments and most witnesses are open. And I still do that to this day. I've been practicing 30 years. I still go watch cases being put on. So that's how you can get probably experience that way.
And just dovetailing with that, for a while, some judges were even having Zoom links if they had a Markman hearing or something like that. I don't know if that's still.
That's a good point. So for Markman hearings, those are still public, and Judge Albright in Waco does a lot of them on Zoom, and those are still being broadcast through Zoom. And if you reach out to his chambers, to his courtroom deputy, she will get you access to the link. And yeah, that's a great point. I forgot about that. They were actually showing trials that way too for a while, but that came to an end. Now it's just hearings. So yeah, that would be a great way to watch
And
the sausage being
for
made.
some context, Markman hearings are when they're arguing what the claim means. Technical arguments.
Right, so the lawyers are trying to explain to the judge what the words of the patent mean. And it can be very strategic because depending on the construction the court gives the claim will determine whether there's been infringement. So it's a very strategic presentation for the parties fighting over what does, like if the patent requires something to be alongside, does that mean side by side? Could it also mean one in front of the other? And that's going to matter because the thing that's being accused of infringing has a particular alignment and they might be alongside, but does alongside mean alongside like this or alongside like that? And so you'll have lawyers trying to convince the judge to read it one way or the other. So it's almost like competing dictionary definitions. Sometimes they're really great PowerPoints and it's a little more interesting, and sometimes it's just lawyers talking. But if you watch it and after 2 minutes you're like, oh, this is worse than anything I've ever had to sit through in college, then maybe you've learned something about yourself. Maybe you've learned that, okay, that's not what I want to do. And you can save yourself a lot of time and energy not going to law school.
It's important to find out what you don't like just as much as what you do like.
100% agree.
I think we have a question. I just have a question about trademarks. So how far can you go with trademarking a name? I know one, you said the name Starbucks is trademarked. Can you trademark something like hotels.com or like the Starbucks sizes like Venti and Grande?
I think you can. So I am not a trademark attorney, and if anyone else knows the
Oh.
answer, just
There's a spectrum in names, right? All the way from generic, something like table is a generic word, all the way to completely, totally made up. Exxon, the way they came up with that name was they totally made it up and they went all over the world to make sure it didn't mean anything in any country. Totally arbitrary, has no meaning. Then there are marks that are maybe descriptive or suggestive, that suggests maybe what the product is but doesn't quite tell you or gives you something about a characteristic. And depending where you are on that spectrum, they're protectable with different types of evidence. If you're at this end with totally made up, it's very easy to protect it. Generic, you cannot protect. And that's why people, like when you go to the restaurant, they say, can I have a Coke? And they say, is Pepsi okay? That's because otherwise Coke will become the name like soda pop, like for carbonated flavored drink. So generic, no protection, total protection here. If you're suggestive marks, you can protect them. Descriptive marks, you can protect them as long as you show that, well, I'll stop there. There's a range of protection.
there's also like interesting rules about offensive marks can't be protected and like where the line is there. I know that there were certain words that the government would not grant a trademark on.
So just yesterday, there was a case where the NHL team in Utah wanted to be called Utah Yetis. And there's a water bottle company, right? And the judge rejected that petition. So they have to now look for another name.
Right. I think if you remember the slide on trademarks, it's a way to identify the source, right? So if you are picking a name that's very Starbucks-y, they're going to come after you because, it sounds like you're identifying with Starbucks.
Isn't that like a Buc-ee's has sued somebody else, a Dallas
I'm
gas
sure
station that is using some kind of an animal that looks very similar?
Oh, in Mexico, they have a Buc-ee's like gas stations and stuff like that.
And the ultimate question when you have similar marks is there a likelihood of confusion? Is a consumer seeing one or the other likely to be confused? And that goes back to the source origination function, right? If it's supposed to identify my product and my quality that I've built up and a reputation, if somebody comes along with a very similar name and bad quality, a consumer may go to them thinking it's my product. And then my reputation it becomes impacted. So that's those are some of those trademark issues.
In relation to the Markman hearings, is there a level of precedent that's set when a judge like determines a definition in one case, or is it like that definition only applies to that specific case, but it changes depending on the matter?
Legally, it only impacts that patent in that case. But let's say the word is vertical. What does vertical mean? Okay, so that judge said it's vertical. Is another judge going to go looking at the same issue going to be influenced by that judge's decision? Maybe so. But one thing to keep in mind is when you're defining a term like vertical in the patent world, it's very specific to how it's used in that patent. So vertical in one patent may mean one thing. For example, if you're building a boat dock, vertical doesn't have to be exactly vertical. It could be off a little bit. But if you're building something to shoot a rocket ship up to Mars, that vertical better be exactly vertical. So the word vertical may mean slightly different things depending on the patent. So it's patent specific, it's case specific, but if the same patent is being asserted against another defendant, the other judge may be looking to the first definition and adopt it as his own. Does that answer?
Yeah, I think we're over time, so
I had one more follow-up, if that's okay.
is that okay?
Does the USPTO ever get involved in any of the patent prosecution cases, or is that simply in like the federal courts?
So just to clarify on the language, because I see this all the time when I tell people what I do. So when we talk about patent prosecution, that's like filing an application with the Patent and Trademark Office. And so people get confused. Like they hear prosecution, they think criminal procedure. So patent litigation is strictly the realm of courts for the most part. Different types of courts now. There's a court, so to speak, at the Patent and Trademark Office that deals with litigation-esque type of work. But when we say prosecution, and we're just talking about getting a patent, getting a trademark, that's strictly at the Patent and Trademark Office, and most other things are at court.
Right. I mean, I think as U.S. Patent Office issues the patent, right? So every activity from the inventor all the way to getting your patent out is at the U.S. Patent Office. After that, you can attack the patent. Either you can go to the courts, or there are also procedures at the U.S. Patent Office where you can attack the patents. That's the
So that second part is litigation.
yes, that's part of the
The
litigation.
first part is the prosecution.
Yes.
And some of us can hang out here afterwards, so if you want to.
Yeah, we'll be around, and if anybody is okay to take a picture with us, we would appreciate that before you leave.
Thank you.